Welcome to Legal Tech Week, a weekly or sometimes weekly journalists roundtable in which we talk about the top stories of the week. I am Bob Ambrogi. I write the blog Law Sites and have the podcast Law Next. And our panelists, as you see them before you today, are Molly. You want to introduce yourself?
Sure. Molly McDonough. I'm a media consultant based in the Chicago area, and I produce the podcast Legal Talk Today.
And Zach?
Hey, everybody. I'm Zach Warren. I'm editor-in-chief of ALM's Legal Tech News. Also see me on law.com, The American Lawyer, Corporate Counsel, and other ALM publications.
Niki?
I am Niki Black. I'm the legal technology evangelist with MyCase law practice management software. And I also write a lot. I write a legal tech column for ABA Journal. I write one for Above the Law. I write a weekly column for the Daily Record. And I also write weekly blog posts at the MyCase blog.
You do write a lot. You've been really prolific lately. Joe?
Joe Patrice from Above the Law and the podcast Thinking Like a Lawyer. And right now blowing up on Twitter. So my thing's just dinging all over the place. So I keep looking away because I tweeted something earlier today that got retweeted by somebody who has 1 million followers. So now it's like ding, 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 ding. And I keep wondering if people are yelling at me or not. I'm freaked out by social media right now. That's where I am.
All right. That's going to be a first, but okay. Steve?
Hi, I'm Steve Embry. I write the blog TechLaw Crossroads, which is about legal innovation and legal disruption. And like Molly, Joe, and Victor, I have worn my black shirt today.
Mine is a Christmas shirt. This is my Nakatomi Plaza Christmas party shirt.
Well, that's a whole other conversation, but Victor.
Hi, everyone. My name is Victor Lee. I'm assistant managing editor with the ABA Journal. I handle the business of law and technology. And actually, you can't really see this is actually navy blue, but it looks black, on screen. And yeah, I was gonna mention that I saw Joe's tweet. I think on one of those aggregators that I follow, and I was just like, oh, that's gonna blow up.
Well, I'm curious now. What was it?
There was a guy on CNBC who cut like a WWE style promo about like how COVID isn't that dangerous and how like going in. It was that guy Rick Santelli who was famous for doing that one of the original Tea Party screeds back in the day, and so he cut some pro wrestling promo about how like COVID was. How being in a crowded, being in a restaurant was no different from being in a big store, or that kind of stuff, and how, you can't tell them what to believe and blah blah blah, and it kind of blew up.
And CNBC was that their host quite correctly cut him off and was like, "Look, it's a public health matter. I'm not going to let you keep saying these things." And they got in a screaming match, and I was like, "Look, this is the point where you've got to fire this guy, right? Like at a certain point, you have to have those sorts of standards, and that's what." Is going nuts.
Fair.
Yeah.
Fair enough. And the whole shirt conversation was actually turned out to be very relevant, what shirt you're wearing, because I just got off a call with Jared Correa, who some of you may know does the Legal Toolkit podcast on Legal Talk Network. I was a guest on his show. And we got into this whole offline conversation. It's not part of the podcast, but we decided we need to do another podcast sometime about swag and a whole conversation about swag. And I don't know if you all saw Joshua Lennon's tweet that he got going this week, where he's vowing, I guess he's asking vendors to send him their clothing swag, and he's going to wear something every day, I guess, and post it on Twitter or something. And I'm like, I mean, that's my daily, that's how I dress every day. I mean, it's some t-shirt from some conference I've been to at some point along the line. It's like,
At first, I thought he was just going to pull things from his closet, and I was like, "Gosh, that's a lot of swag." And then I started kind of doing an inventory. Do I have that much clothing? I have my core pieces, Fast Case and are my favorite T-shirts, and some of those. And Clio has really soft T-shirts. So, but I don't think I have nearly that much. But I think Joshua might even just have enough socks.
Right. And then
Well, I have a lot of swag from one company. It's called MyCase. I probably have 30 pieces of clothing for real. Like,
You should definitely send some to Joshua Lennon.
yeah, definitely send it to
I was always getting those reusable bags because my wife likes using them for like shopping. So I would take like a bag from every conference that I went to. So I have like 4 or 5 like Clio bags, a bunch of Tech Show bags, and so it was great. But then once they stopped allowing us to use reusable bags for shopping, then it was kind of like, all right, now we have all these bags. What do we do with them?
That's what I was going to say too, is we were moving over the summer and my wife said, so what is ILTACon and why do you have stuff packed in bags from 3 different years to move? And I'm like, well, if it's there and helpful, then it's there and helpful. So not going to argue.
I still have a large supply of this famous TechLaw Crossroads no BS t-shirts. So
yeah, that was good. Well,
you can always wear those forever.
think, it's holiday season. Think of those you love, Steve, and we all take one. I've got my MyCase shirt right here, my MyCase cup right here, my Clio shirt on. But as I said to Joshua, how come nobody does legal briefs? That's the one thing I haven't seen in the whole swag department. But anyway,
because nobody would see it. The whole point is for them to see your logo.
I
it's
guess
your underwear.
That makes
Some
sense.
people would
they do
it,
socks. Who sees socks? Everybody sends socks. How many people see your socks?
When you cross your legs, I don't know. Or you could wear high waters, maybe. I don't know.
Yeah. All right. Well, from swag to the big news of the week, virtual conferences.
It happened, everybody. It's finally happening.
It happened. I mean, how long have we been talking about? How long has Nikki been talking about this?
Right. I'm obsessed. So,
but she is vindicated. She is vindicated this week. So what happened, Nikki? You want to fill us all in, or?
Well, so Steve was kind enough to tell me about the e-discovery day that EDRM was hosting a virtual platform for a portion of that e-discovery. The sort of, I guess it's like a celebration. I don't know if it's conference. I think it's a conference every year. But so they had a virtual platform where you created your avatars. And it really felt like a conference center, kind of like the that one in DC that's outside of DC, the Harbor Bay, or I forget what it's called. That one that we've gone to for National Harbor. It felt a lot like that, sort of like a campus. And it had buildings, all different kinds of buildings, and a beach and a boat and a lighthouse you could walk to the top of and look out at the view. But it was. I thought it was awesome because you had these serendipitous meeting interactions with people, and people were laughing out loud sometimes. Like it was a lot of fun. I met a lot of people I never would have otherwise met within the first few minutes of being there. I went on a whole bunch of boat rides, and we learned that if you weren't standing up when the boat took off, or if you stood up when they stopped the boat and then they started the boat again, you would slide off into the water and they'd have to come back and get you. It was a ton of fun. And it sounds strange, but it felt a lot like a conference because you could say, hey, let's go meet up here. You'd go and find somebody or walk into the expo hall, and you would stand around and talk to people, and you felt like you were talking with them. I don't know. You guys tell me what you thought, but I thought that it really added to that flat virtual, just zooming all the time, which gets super boring. But you guys, some of you were there, so tell me what you think.
I had a great time. I mean, the good thing about it was you would see small groups of people having a conversation, and you could walk right up to them and join the conversation. In fact, Nikki, I think you said it's a little bit awkward, sort of like in real life when you walk up to a group of people and maybe one person, and but then if you walked away from that conversation, the voices would fade into the background just like normal, and then you could go to another one. And the exhibit hall was really interesting because there were booths, and you could walk up to the booths, and if somebody was, in fact, I bumped into Bob at one of the booths, and we sat and talked for a little while, and then we moseyed on and ran around, and I thought it was. I don't know how a presentation would work with that, although they did some presentations. They had a drink mixing thing and a memorial for Gail that was sort of on screen. But
the presentations were live, were actual video of real people, right?
Yeah,
the one I saw.
Not
the
avatars,
only one I saw. Yeah,
right. And that was a little. I don't know about that, but just the interaction part of it, was great. I mean, I bumped into Bob and Nikki last night. That you had an ability to find somebody's name and that would take you to them. And I took around all these little corners and nooks and crannies. They were way in the back in the corner by the beach, someplace that I never would have found. And we just sat there.
The reason we were there was because I was at the beach and I went over to the boat and I was going to try and drive it. And some guy jumped on the boat. He never introduced himself. He never talked to me. He just drove the boat away, got out of the boat and ran away. And so I was like, I'm going to explore where I'm at. And so I wandered around a little bit, and all of a sudden Bob showed up and then Steve showed up, and we're in this random weird place where there was nothing going on, like by the beach.
Yeah. We were talking on the Ari Kaplan lunch, I guess, yesterday. And Ari brought up the fact that with the video games that, a lot of the kids play, like the Madden football games and the basketball games, the players are very lifelike and very realistic. And I wonder at some point in the future whether we'll have the ability not to be sort of this wonky looking avatar that they had you pick from, but will really look more or less like us. And we get to that point, I think that would be cooler, but maybe it wouldn't. I don't know.
But that's actually one of the interesting things was how much, Nikki, I wish you could show your avatar, because your avatar looked like you.
Yeah. And
Steve did a pretty good job with his avatar. I didn't see Zach. I didn't see yours. Molly, I walked right through you at some point. I don't know how I did that. I was thinking I should get like a brain meld or something when that happened, but it didn't happen. But one of the things I thought was really interesting that also made it feel like a real conference is like you land in the sort of welcome area when you first log in, and it's like a real conference in that you're like, okay, like where do I need to go? What room am I supposed to be in? Where's the exhibit hall? How do I get there? And you're kind of like going through this process of exploring the area a little bit. And then, as you say, you can kind of join conversations, but it's also interesting that the sonics of it are such that if there's a group of people talking, as you get closer to them, it gets louder and louder until you're right there, and then it's like full volume, and you can kind of walk over and as Nikki said, it's sort of awkwardly wait to see if they notice you and say hello or not, or reach out and shake their hand. But it's very much like a real experience of being somewhere, or at least as close as I've been in 8 months to being at a real thing. So.
Yeah, the way they did the panel discussion was pretty slick too. I popped in for that for a little bit. Ron Hedges, Mary Mack, and a few other people. Essentially, they had a video board, which there were video boards all over the place. You could put advertising and such, but they had pre-recorded essentially a Zoom call, and it played seamlessly on the video board in the virtual world. So it was a bunch of people seated like they would be seated in an auditorium. You could mute the crowd. They had the capability in those rooms, and then it just played the presentation. So I thought that was kind of a cool mix of still getting that lifelike feel. You're able to see people's faces on the board, see the PowerPoint that they wanted to, but you're still in this virtual world. And like I did halfway through, if I wanted to check something else out, I could get up and go check something else out. I liked it overall. I've also got the exhibit hall behind me, and you could even see like names of vendors and people standing at the booths as you were walking by. It was cool.
Yeah.
And the one thing that was funny. Oh, sorry.
No, I was just going to say, I thought it was great. I thought there have been, I think Sarah Glassmeyer just mentioned that it sounds similar to Second Life. I've seen lots of comparisons to Second Life and Minecraft. There are, like Steve said, opportunities to really make this more realistic. But I thought that it was great to be able to have these interactions and to be able to go off into a corner and talk to people. I did meet a few people, which was great. That's always a bonus. And the other thing is, if folks are doing this, the thing I would recommend the most is that you find a way to on-ramp your audience so that they test it out. Because Nikki spent a lot of time and then prepped us on how to get get going with some kind of simple instructions. And I didn't get that from the conference. So, that
not to mention
kind of
how to do
on-ramp
backflips and other things like that.
How to dance.
Right, for the advanced users. But just having that, encouraging people to spend 15 minutes creating their avatar, getting ready, getting everything set up was really helpful. It was still a little challenging to get moving around the first time, but having spent a little time in advance really helped.
Since Bob complimented Niki's avatar, Niki, if you would move a little bit, we could all see your avatar.
Look at that. It's like a spitting image.
Well, the other thing that was interesting about it was, Bob sort of alluded to it, when you're near crowds of people, it's loud. So at one point I said to people, I can't hear you. It's really loud. Let's move over here so we can talk where it's quieter. And as we're all walking over to this and it was funny too, because people didn't know how to walk. So they'd completely overshoot and end up 10 feet away and have to turn around and come back and then awkwardly turn their avatar around so it was facing the other people. But, it was just so strange. It felt like we had to move away because it was a little bit too loud where we were.
I definitely ended up in the woods. Yeah. I ended up in the woods and on the hill by accident by the
I feel like I came from
just like every conference you go to.
You're right. But I feel like I interacted with people and I feel sort of invigorated, like I feel after conferences, and not hungover though. None of that hungover stuff going on. So that was good. So
yeah, the virtual alcohol wasn't so good. So we actually and Kaylee Wallstead, who is here listening today, who's she and Mary Mack were the two at EDRM who came up with this idea and made it possible. And maybe stay tuned. We're talking to Kaylee and Mary about maybe we can set up so we can do our Friday virtual roundtable sometime in this virtual environment and sit around and talk and have everybody get a taste of it. So that would be really fun if we can do that. And also love that when Niki and Steve and I went looking for Kaylee and Mary at this conference to go ask them whether they might consider this. And they said, sure, but first they made us dance before they listened to our conversation. So
20 people, we showed up right at the beginning of a group dance. Or after we do the group dance, they're 5, 4, 3, 2, and then everyone just started dancing. 20 people, and everyone was laughing because it was so funny. People were just guffawing. It was I don't know, it was a lot of fun. It was surprisingly fun.
Yeah. Somebody's asking, Joe Scott is asking how this is different from the Legaltech virtual conferences they tried a few years ago, but never caught on. Maybe just the COVID times will make it work now. I don't actually remember the Legaltech virtual conferences.
Those didn't have avatars though. Those were just literally like all the other flat conferences we're seeing, if I remember correctly.
That's what
it was basically just, you show up and it's a web page and you click on links to, it looked like a, conference hall or something, but really it just was following links to the vendor's little presentation or following a link to a webinar. And that was just like all the other conferences. They're very flat, in my opinion, and boring.
Curious. Oh, go ahead. I was just about to say, I am curious though, if this is something that will continue even beyond the COVID times, because it is one of those things, as we're talking about it, it feels so lifelike, like you're at an actual conference. But when you can go to actual conferences again and have those experiences, is this something there's still a place for? I think there very well could be, because it draws people from all over the country. You don't have to pay travel costs, etc. But still, it's nice to have the in-person experience, obviously. So I can see kind of both sides of it.
Yeah, I think really probably the most impressive part of it would have been, I think, for the vendors. I don't know. I'm not a vendor, but so far I've just not seen a virtual conference that has come up with a good way to get the attendees and the vendors to interact. And this was very much, as everybody said, I mean, you wander around the exhibit hall, you see a booth that interests you. You can see that there's somebody standing there or not. You can see which booths had people standing there or not. You wander over, and it's a you're having a verbal conversation with the person, not just texting or something. And it's, it may be somebody and you ask them how they've been and what's up. Or if it's not, you can ask them about their product and they can talk to you about it and show you a little demo. It was very realistic in that sense.
Yeah, I like that too. And I was wondering, Bob, as you were talking, whether vendors who, from everything I've heard, are very dissatisfied with sort of the quote exhibit halls that we have had so far, they may very well insist on something like this in exchange for paying, the exhibitor fees, because it is so much better. I mean, you can actually, who's there. It's not like you have to enter a chat room and you don't know who's you'd be talking to, who's at the booth. You can see them, you can interact, you can have a discussion, you can see a demo for all the reasons you said. And, I'm not a vendor either, but if I was, I think for my money's worth, I would much rather have this than the other options that have been out there so far.
Yep. So what else is there to talk about this week? I'm looking at, we have this fancy spreadsheet set up that people are supposed to enter their stuff in, and a lot of blank spaces on it this week. So I'm not sure.
I put mine in.
You put yours on the wrong day, though, Joe. You put yours on last week's tab, but it took me a while to find it. You're there.
Oh,
if you're talking about Pacer, is that what you're going to talk about?
Yeah. No, I thought we were just updating it at the same page every week. I didn't know
we have a little tab for each show. A tab for each show.
We're keeping it for posterity. Interesting. Okay. Yeah. I put stuff up. That's all I.
All right.
That was what I did.
All right. Well, you get credit. So what did you put up? What do you want to talk about?
So Pacer. We've talked before about the Pacer lawsuit and so on, and the growing attention people are giving to the idea that the federal government charges us for public documents at 10 cents a page, despite the fact that that's not been a reasonable thing to be charging for years. At this point, there's now a bipartisan bill to make this change, to make Pacer free and give access to the courts. And what came up is that apparently the administrative office of the judiciary was sending out talking points to federal judges for them to use to lobby Congress members to vote against this bill. It seems dubious ethically to do that. It's really a lot of the things that were said in these talking points were wildly insane. They were making comments that making Pacer free would require an investment of $2 billion to make a database for static documents. Really, really weird stuff. And it's troubling that the judiciary would condone something like this.
Yep. Anybody have thoughts on that? Yeah, I thought it was pretty bizarre that the judiciary was doing that. I just do we know, has the bill moved recently, or do we know what the status of that is? Or
it got out of committee, but I don't think anything's happened since then.
Yeah.
Yeah, I mean, I know that with the line between what judges are allowed to do, as far as lobbying goes, I know that's always been kind of a gray area and not something that's really. I mean, sometimes some justices historically have had no problems going up to Capitol Hill and be like, I think you do this, and this, and then sometimes they'll go and testify formally. But yeah, it just kind of smacks of getting talking points from a to then go and lobby Congress. It just seems very unseemly. But I guess we live in a different age now.
Yeah, there was the ruling from the federal court in August on Pacer fees that basically I'm trying to remember what happened. They basically said that you have to send the case back, I think, to the trial court for further proceedings. But basically, they did find that some of the fees were being excessively charged, as I recall. I'm trying to remember. I forgot to look back at that today. But
yeah, absolutely. And one of the points that you made in your write-up of that originally was that,
which is what I'm trying to find.
Yeah, no, I read it. It's actually linked in my piece. Yeah.
Okay.
But one of the things that you pointed out was that the ultimate end of that lawsuit was we need to rely on Congress to make the change, which you said, getting Congress to agree on something. But this is weirdly something that there's bipartisan support for, because amazingly, we can all come together about the idea that this is insane. Unfortunately, not about, more pressing matters that are insane, but hey, it's a start.
Yeah. Yep.
But what else is new?
I don't know they'll have time to pass it though. I mean, it seems like Congress has more pressing things to discuss. Not that PACER isn't important, but yeah, I mean, between COVID relief and between all these other things. I don't know if they'll be able to get to it before the end of the term, which means then they'd have to redo, start from scratch at the, for the next term. But who knows? Maybe it'll be a better thing to just start over with the new administration coming in.
Right. Well, since Courtney Troutman here in the audience thinks that PACER is really exciting and racy, we have more court docket stories to talk about. Right, Molly?
I just wanted to bring up a demo that Steve and I got to see on Tuesday by Trellis. They've been expanding into different states and just came into Cook County, Illinois, and they're doing these analytics and data points for the state courts. So where we've been relying on the trickle-down effect of guessing kind of what jury verdicts would be based on what's happening in the federal courts in aggregate. They're really looking at aggregating full state data and really interesting points. And I was excited to see them coming into Illinois, or just interested at least, because I know Illinois is really tricky, like actually a lot of states, to be able to get the full state. So
how do you know that?
I personally know that because in 2001, and I have show and tell, I created the Illinois trial reporter for ALM and had to work with all 102 counties to get the data that Trellis is now aggregating by state. And I think Steve referred to it in one of his posts as the Google of state courts, of the state courts for data. State court analytics.
Yeah.
But this is, verdict intel. They're starting to be able to drill down by party, so that you can see a judge's stats, whether they, what their record is ruling on behalf of plaintiffs versus defendants. And I mean, this is really in the weeds information that we just haven't had access to, that, maybe through some of the state trial verdict reporters that we've seen in the past, and there are some, the Chicago Daily Law Bulletin does this for Illinois, but there really aren't very many competitors to them in Illinois. So it'll be really interesting to kind of see how this shakes out, how controversial it'll be with some of the states. We talked a little bit about that, whether the judges will push back. What was kind of exciting to me is that the data that they're collecting is very similar to what I'm seeing Miami courts using to be able to improve their case management systems. So, I can see the courts really wanting this, especially the courts that don't have the resources that Miami has, to be able to subscribe or use this type of data that's coming in from a third party, looking at their system. They're aggregated across the state. So it'll be really interesting to see how this develops if they're able to get into more states. And what I thought was unique about them is that they really are focused on state courts, to the point where if there's a county that can't get them the information electronically, they're still sending runners to pick it up so that they can get everything.
Oh, that's impressive.
Yeah, I did. I interviewed
That's the
Nicole
old way of doing it,
and did a post on it some time back. I was really high on it. First, Nicole is a former litigator and in state court, and so she has a good feel for what litigators need and want out of some of these analytical programs. And the reason I called it one of the reasons I called it the Google of state court analytics is that you can Google an inquiry about a state court or holding, and the Trellis site will pop up, and you can get some information out of it for free. And then, of course, it's a little teaser to bring you in to get more. But I thought that was really neat. And the search capabilities were really quite interesting. And, Molly makes a good point, and it's the point I made it. Getting information out of state court, county court clerks is not as easy as you might think. I mean, you do have to do some snoozing with a lot of these people for them to cooperate with you, since it's not necessarily their job or their highest priority. So I can imagine all the work that the Trellis folks have had to do in gathering this. And there are competitors, and it's kind of a crowded space. I mean, LexisNexis is wandering into the state court analytical area too. But the impressive thing about Trellis, I thought, is this is all they want to do. I mean, they are laser focused on this. And as we all know, successful startups often are those who are very, very focused, and they are.
Yeah. I mean, there's Gavalytics out there also, which is very similar in terms of their focus. They're getting into more and more states. I mean, they were just California when they launched, as was Trellis, and they're also expanding. They're saying now that by the end of the year they'll have 20 states coverage in 20 states, but not 100% coverage. It's major metropolitan areas anyway in those states, and Lex Machina has been expanding its state coverage as well. So I don't know if I'd call it a crowded space so much, but it's definitely a space in which there's a lot more activity going on.
That activity, I think, is going to be something that's interesting to track, though, because it does seem like a little bit of a gold rush where everybody started in California. The data there might have been a little bit more accessible. And now everybody's just trying to pick off, like Lex Machina trying to go into New York, Gavalytics trying to go into Florida, pick off these individual states and establish their market share before anybody else can get there. So whoever wins that race probably will have a leg up for a long time. It's just a matter of being able to be the first one to get that data. And whoever I don't have a prediction or a horse in the race, but just as an avid watcher of the space, I'm very interested to see who wins that rush.
I was telling somebody the other day, it's a great time to be a litigator, right? You got all these companies competing in the field on price and quality and service. And, if you're a litigator now, you go, wow, look at all this stuff I can get.
Steve and I argue over who came up with the phrase that if you're not using litigation analytics, you're committing malpractice.
Bob.
I think that Zach's exactly right. And to Steve's point, that this is, the difference though is going to be what Steve is saying is, you can really compete then on price and quality. And one of the things that I think that I found so attractive with what I've seen so far from Trellis is that they're focused a lot on user experience and intuitive use. So it's just a really easy product to navigate just by glance. And that's got to be a decent selling point for them. But it'll be harder for firms, I think, to shop around, and the more folks come into the field.
Yeah. The one other big hurdle for all of these companies is that there are some states that just don't have easily accessible docket information in any electronic format. Massachusetts, where I am, being one of them. There's just the Massachusetts courts have been highly protective of their online data and make it very hard to get access to docket data, especially for any kind of commercial providers. And other states are in similar situations or don't even have the data really adequately available online. So that's a speed bump for all of these companies in trying to get all national coverage. But we'll get there eventually.
Yeah, and it's for example, in my state, it's electronic filing is still optional. But having said that, we don't want the perfect to be the enemy of the good. Any information and data out there is better than, sort of the wild ass guess that most of us have lived with for our careers. So yeah, I mean, it is going to be difficult, and going back in time is going to be difficult because, even if a state were to today say we're going to do solely electronic filing, they're probably not going to go back and put all their paper filing in data form. But as time goes on, we get more and more data and we get more and more information, and, query, what good is litigation data that's 10 years old or 5 years old anyway, really, when you start thinking about it.
True. I guess that's true. Looking at lots of empty spaces. Victor, you had something you wanted to talk about this week. You want to fill us in on that? Yeah.
So I guess there was a story that I saw in ZDNet about how I guess IBM's cybersecurity division found that hackers from a nation state are targeting the links of the potential distribution chain for the COVID vaccine. And I think they're probably hesitant to say who it was, but I think based on the emails that they published and sort of the phrasing of certain words, it's pretty obvious it's China. But I think one thing that they were doing like a phishing kind of campaign targeting people because it used to be that they were just focusing on manufacturers like Johnson & Johnson, Pfizer, but now they're looking at who are the companies, who are the industries, organizations that'll be responsible for helping to transport the vaccine. So I think they targeted dry ice manufacturers, they targeted transportation companies and things like that. So I think it just shows you that hackers are never going to miss an opportunity to try to get an advantage, to try to get their hands on valuable data. It doesn't matter what it is. Even something like something as important that you would hope that would be safe as possible from interference that we're all relying on, like distribution of a vaccine for COVID. Hackers are still going to try to make their play and try to get this information, and nothing is safe. And people really need to be cognizant of that and need to again brush up on their basics. Make sure they safeguard everything, and don't open any emails that look suspicious.
And I think there's actually that, in addition to the broad interest of that story, it actually maybe loosely relates back to one of the legal tech stories of the week, which was Extero's announcement yesterday of its acquisition of access data for, we don't know how much, but 9 figures, somewhere north of 9 figures is all we know, and that's a big range of north, but. I think part of what part of the reason Extero wanted access data, various reasons, but part of it was for its access data's sort of data breach and data breach analysis tools. I think Extero is really trying to position itself as a sort of soup to nuts data software company for the legal community, and that whole area of data breaches and investigating and responding to data breaches and detecting them is a major area of focus if you're going to be dealing with data. So I think there's a relationship there.
Yeah, when we talked to Extero about it yesterday, Reese Dipshan with LTN did, and they basically made the point that, if you're still thinking about e-discovery as kind of its own little self-contained bubble, you're probably looking a little bit too narrow, because not only is data all across the enterprise and has so many different uses, but even e-discovery tools can be used for information governance, for privacy, etc. It is kind of all increasingly wrapped up in one these days. And there are a couple different ways that I know e-discovery companies can go, whether they're really doubling down on technology and review, kind of like somebody with Reveal was doing with NextLP, or you can go the other way with Extero, really go into privacy and data breaches. But in the end, it is all data. And that's something that all organizations in a lot of different forms are having to try and grapple with now.
Well, one of the issues that I've seen come up several times lately is, when a law firm produces data to another law firm, what obligation does the producing law firm have to make sure that the law firm that gets the data can adequately protect it, that has adequate safeguards in their system to prevent it from being hacked and personally identifiable information being revealed. And, it's a dicey area because, most law firms are going to say, well, of course I do, and what are you going to say? Give me the proof. You're going to go to the judge and ask the judge to show you the proof, or, it's a thorny area, and it can be a sticky wicket, I think, for law firms that are producing massive amounts of sensitive data.
Yeah. Sorry, Zach, if I just stole your story, but I figured you'd comment.
I didn't put anything in the spreadsheet this week, so no, you didn't steal anything. It was my bad.
Yeah. Well, anything else you want to talk about this week?
Put me on the spot now. We talked obviously about the Avatar conference, but just eDiscovery Day in general, I think is definitely worth a mention, because it is something, in speaking of Xtero, that they started 5 years ago. And I think a lot of people saw it as, oh, this is just going to be Xtero's little thing. But I think it really has grown to be an eDiscovery Industry Day event. I was on a webcast yesterday that was Lighthouse eDiscovery, not even Xtero at all. EDRM had a bunch of sponsors, including Xtero, but they're an outside organization as well. So I do think it's kind of fun to see so many people adopt eDiscovery Day as something that is worth celebrating, and that has grown from being just one vendor's day or one vendor's conference to being kind of more of an overarching industry thing.
Except that you're lobbying for it to be renamed Discovery Day, right?
Well, by the results of my survey, there are a lot of people that would like to drop the E. I'll roll with it for now.
Okay. Yeah, I actually thought about that when I was writing about it yesterday. Do I want to call it Discovery Day? All right. Steve, how about you? What you have this week?
I mentioned an article by Dan Rowe, who was talking about an increase of contingency fee billing arrangements with business litigation. And the firms that he mentioned were either a stand-up, well-known plaintiff's law firm, or they were boutique firms. And so I wrote a post commenting upon the difficulty of most law firms whose business model is bill by the hour in adopting contingency fee arrangements or alternative fee arrangements. And it's mainly because the compensation and advancement systems of those firms, most billable hour firms, hinges on number of hours that you bill, if not in whole or in part. Certainly for associates, it's a key component. So when you're trying to manage a contingency fee case, more is less, right? You want to have the work done by the lowest cost provider that can adequately do the work, and you want to reduce the amount of hours because that expands the amount of profit. And so try asking an associate, hey, would you like to work on this contingency fee case? He says like, oh, no, I don't know about that. I've got to reduce, you don't want me to bill as many hours. And the same is true for partners. I mean, most big law firms have partner quotas that look for partners to bill hours. And so those firms, they're now left with a choice, right? They can either say, okay, on a contingency matter, you don't have to record your time, which is not very likely, because how else are you going to evaluate what a lawyer has done over the years, or you're going to say, okay, record your time so we can assess the profitability of the matter. And so then what happens is, since there's no client looking over everybody's shoulder and saying, I don't think that's a good usage of time to research that to the bitter end or to fly all over the place and take depositions back when we had that opportunity. So what happens is more time is plunked in the matter than maybe would be if there was an actual client reviewing a bill. And at the end of the day, the firm management looks at the fee and the result and says, we lost money on this deal, which may or may not be true because the assessment is based on billable hours as opposed to profitability and end result. And so, what I've seen over the years is, despite all the brouhaha over alternative fees and contingency fees, at least in most larger law firms that bill by the hour is it's just not been that well adopted and not been that not profitable because, and again, even in estimating those kinds of fees and making the profitability estimates, most law firm leadership assesses hours. How many hours is this going to take us to get to the end? Whereas a true contingency fee lawyer will look at how long is it going to take me to get to the end? What is the potential payoff? And how much time will have to be spent on the matter? What's the minimum I can spend on the matter and still get the best possible results? It's a different evaluation. So that was my post for the week is, how difficult I think that is for many law firms whose business model is primarily the billable hour.
Any thoughts on that?
Despite all their rage, they're still just billing rats in a cage, I suppose. Yeah. No, I mean, like we've been talking about it, I got into this business, I started writing an ATL like 8 years ago or something like that. And I think one of the first things I wrote was about the coming alternative fee arrangement thing. And that just never, I think I write one of those every year and it just doesn't get over the hump.
Right.
Yeah. I mean, how many of those alternative fees are really just like discounts on hourly rates? I mean, how many of them were true alternative fees? A lot of them were just billable hours, but just different, just either tied it up differently or marketed differently or called something else. I mean, it's just especially for something like, I mean, just even I mean, one thing that we've been reading about and just reporting and looking at is just like even for clients, like they want that predictability. They want that to know, like even with an hourly model, they want to know, okay, this is what's going to cost. This is how long it's going to take and whatnot. And contingency model, it just seems like it's just way too much variation.
Well, I did one back in the late 90s for a series of repetitive cases, and we ended up setting a flat fee for the year for all the cases with some collars on it. So if it was too much below, then there was a break, and if it was too much above, there was a fee break, and that worked pretty well, in terms of satisfaction by the client. Although I remember when we first proposed it, the first comment was, well, what's going to keep you from, not doing any work and collecting a big fee? And I said, well, what's going to keep you from asking me to do all the work and getting free work? I mean, there's a certain amount of trust that has to go along with it to make it work. And I love doing it and really learned a lot about how to better manage cases and assess what was truly necessary to be done in cases to get a good result, and looking for alternative ways to resolve cases to get to the end. And it was a fascinating experience, but it was a hard to navigate that within confines of a billable hour law firm.
Yep. All a good argument for more data and analytics and law firm billing and time management.
And I think there's also a break that can be made analytically, looking at different kinds of work too. Because I remember when I was a pup lawyer way back, so not very long ago because I'm very young, but some time ago, that structured finance deals my firm was doing as a flat fee, because those were very predictable transactional work that they could just churn out on a fee. But litigation obviously was never going to be that. And I think there's ways in which we can identify different practice areas that have work that is, that can be handled that way efficiently.
Well, and criminal defense lawyers have always done flat fees, and I still have this, I started my career as a criminal defense lawyer, went to a firm that did civil litigation and criminal defense. And we did civil litigation from both the plaintiffs and defense side. And for some reason, even though I did handle my criminal defense matters on a flat fee, from a civil litigation perspective, I always found it incredibly difficult to translate that to civil litigation, even though arguably, in many ways, you should be able to predict how long, especially with slip and falls, for example, like those types of cases, they're pretty predictable. And you would think that you'd be able to predict what's going to happen in a case. But or even a car accident. But sometimes you get all these like multiple all these indemnification actions stemming from one single action that you never expected. It becomes a lot more complex. And sometimes you'd have summary judgment motions on this one indemnification claim that, arose from this original, you thought would be a simple lawsuit. So the civil lawsuits seem to kind of expand unexpectedly in ways that criminal defense matters just simply didn't. But, it still seems, in theory, you should be able to do these flat fee, especially if your firms handle a certain kind of case over and over again. But sometimes it's hard to translate if it's not how you normally do it.
Yeah,
maybe the right model isn't even. Maybe the right model isn't even billing by the case. I mean, if a law firm is really studying and analyzing its work and its analytics over a period of time, then maybe it doesn't come down to a matter of I made a profit on this case and I didn't make a profit on that case. Maybe if it's at the end of the year, we're making a good profit on all of the cases that we're handling. Maybe that's really all that matters.
Yeah. And then there's a difference too between a flat fee and a contingency fee case that's kind of important, because with a contingency fee case, you do a really good job, there's a big bonus. I mean, you have an opportunity to hit a big one, right? With a flat fee on the defense side of a case, nobody has yet come up with a way to have that pot at the end of the rainbow. So basically what you're doing is, you're hoping that your costs are less than what the fee is, as opposed to, my costs are going to be X and the result is Y, and I get to share in the bounty of the result. So the upside potential is a lot different, which also complicates the matter. But you make a good point, Bob. And I remember when I first started practicing law, I worked for a law firm that had a client, and without going into too much detail, what they did was it was a long-term client of the firm with substantial billings. And at the end of the year, the partner in charge of the client would send a bill for services rendered with a number. And, if the client was happy and thought it was fair, the client would pay it. And I guess if the client wasn't, it didn't. But
Well, meanwhile, the chat is flush with new ideas of how to engage in alternative billing, as somebody appears to have paid for legal services with a new bathroom that doesn't work. That's great. One other story I was just going to mention. I didn't put it in the spreadsheet. I'm guilty, but it kind of came out of a conversation we were having here a couple of weeks ago about. I wrote a column on Above the Law about this sort of this convergence of all these different legal tech marketplaces that sort of suddenly all seem to be coming out of nowhere at more or less the same time. It started just a couple months ago with this Legaltech hub getting launched. Nikki Shaver and her husband Chris Ford launching this site that was going to be the world's most complete directory of legal tech companies, and then in short order. Ora Carrington has released to the public this thing, I guess, that it had for a while called the Observatory, which is a directory of legal tech products. Then Thomson Reuters announced its Marketplace, which is, again, a kind of a directory of products that integrate with mostly with HiQ, I guess, but where you can also, one of the interesting things, you can actually kind of test things out. And, we all know Rain in Court is out there and is moving along. And Rain in Court has also been working on introducing this sort of sandbox feature where you'll actually be able to kind of try before you buy products in Rain in Court. And I completely forgot in my Above the Law column to mention this other site, Theorem, that has been in the works and is going to be formally launching sometime pretty soon. That is also a legal tech directory and much more. So I just thought that was really interesting. And the genesis of my writing that column was a conversation we all had here a few weeks ago. So it's okay to steal from our conversation, I guess, and write other stuff about it. Anybody else have any good of the order? Anything else they want to raise?
Well, I threw an article in there I just wrote an article that was published today for the Daily Record. And I thought it was really interesting. It was a West Virginia court case where a law firm was held not to be liable for one of those real estate email scam schemes. And essentially what had happened was the law firm used encrypted email to communicate to the plaintiffs, possibly their realtor, I can't recall, but to communicate the wiring instructions. But then what happened was that I think the plaintiffs, somebody, either the realtor or the plaintiffs, I think it was the realtor, may have sent the plaintiffs a screenshot of the wiring instructions through regular mail. And then there were all these conversations between the realtor, a broker, and the plaintiffs, the purchasers of the property. Over time, and somehow a company, some scammers got involved and got in the middle of the conversation and changed the wiring instructions. And the $250,000 for the property disappeared into the ether, went to account somewhere, disappeared, and that was the end of it. So the buyers, the plaintiffs, brought an action against the broker, the realtor, and the law firm. And the court, for a number of different reasons, eventually the broker and the realtor settled. But the case that I wrote about was the West Virginia Supreme Court concluded that the law firm was not liable because they'd use encrypted email. And then they also ruled that evidence that had been submitted by the plaintiff to try to prove that as a matter of course, they had an obligation to advise the plaintiff of these different kinds of risks and these real estate schemes so that they would have known to double check or that the lawyer should have called and double checked, that somehow the lawyers had some additional obligation to just using encrypted email. And the court determined that the evidence that they tried to submit to prove that there was this standard of care that was breached in that regard was insufficient because the expert didn't know enough about West Virginia law and lawyers and their customs. But at the end of the day, the law firm was off the hook because they'd use encrypted communication. So they didn't have to reimburse the plaintiff in any way, or they were held not liable. So I just thought it was interesting because it was a situation where the law firm did the right thing. And it was just sort of one more indication why law firms should probably start using some sort of encrypted communication. But it really caught my eye because that saved the day for the law firm. And I wrote about it, but it's up behind a paywall, so I can share the link, but you'll only be able to read the first, 2 sentences.
But don't you put the stuff up on your own website too? I always find your columns on your website, but maybe I'm not supposed to find them there. I don't know.
No,
Yes.
I do put them up on the blog because I have permission to republish them. I just haven't. It's published in the paper on Monday, and it was published online today. So I just haven't had a chance to do that.
I don't know if there's any cause and effect relationship here, but West Virginia, I think, is the only state that makes mandatory the comment 11 or 8, whichever it is, the technological competence standard, which most places says that the lawyer should keep abreast of the risk and benefits. And the West Virginia version says the lawyer must keep.
That's super interesting. I didn't know that.
Yeah. I didn't know that.
Think it's also-
I gave a presentation in West Virginia not long ago, and I kept reading it going, wait, it's different. It's must. It's not should, it's must.
Adriana just mentioned portals, and even with portals, the issue is still the client or took a screenshot, and you can't, that's still, what are you going to do? Like, how can you have to kind of be vigilant, but if your clients are going to take screenshots and share that information.
Well, but in that situation, if everybody was part of that portal, all the people involved in the case, the realtor, the lawyer, the broker, and the client, there would have been no reason for the client to take a screenshot and share it because or else they would have shared it through the portal. You know what I mean? Or the lawyer could have shared that information with everybody within the portal. So portals. I agree.
Yeah. One other comment on that I happen to have on my podcast this week, Andy Perlman, Dean of Suffolk Law School, but who was also the reporter to the ABA Commission on Ethics 2020 way back a decade ago. That's what came up with the duty of technology competence and all of that stuff. And he was saying on the podcast how he was really surprised that the Rule 1.1, the duty of tech competence stuff, has been such a a point of discussion and focus in the year since, because everybody on that commission assumed that was already a responsibility of lawyers to be competent in technology. And what he thought was the most radical part of the reforms and these were adopted by the ABA in 2012, were the Rule 1.6 provisions regarding a lawyer's duty to protect confidential data. And he's been surprised at how little attention, relatively speaking, has been paid to that responsibility on the part of lawyers. So goes to show you. All right. Well, I think we are well out of time here, but appreciate everybody participating and everybody in the audience staying with us. And we will be back next Friday, same time, same place.
Thanks, everyone.
See ya.
Weekend.
Have a good weekend.
Have a good weekend, everyone. Take care.